From London to Ghana, yeah. BWF in the house, let's go. Integrity, excellence, we rise together. We stand with you, we stand with you. BWF, when the path is tough, we'll pull you through. From Seven Sisters to Accra too. We stand with you, we stand with you. On the high road in London town, 2028 on a house we're found. And Christine the sound. Family, immigration, wills and probate, we're around. 30 years strong in the game. We got a law in our name. When life gets heavy, we lift the weight. Together we claim the fame. Oh, you want a dream? You need a team. BBUF by your side, shine like the stream. From Accra's Golden Dawn to London City Gleam.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Good morning and a very big welcome to today's edition of Legal Hour brought to you by BWF Solicitors. Our lovely host, Manya T, is not available today, so I will be your host. I am Pamela Oakley from BWF Solicitors. Very welcome to you. If you are joining us and it's morning, good morning. If you are joining us and it's in the afternoon, good afternoon. If you are joining us and it's in the evening, good evening. Please, as you have joined us, don't forget to share our video with your friends and family, as what we are going to discuss today is a very, very helpful topic, and you might never know who it may help. So please share and also comment and like on our video on our YouTube page. Our resource person for today is none other than our very, very educated Charles Asma from BWF Solicitors. He will be giving us today's updates. So, hi, welcome, Lawyer Charles. Welcome to Legal Hour today. Do you have any
Hi,
updates for us?
hi Pamela, thank you. Yes, so by way of update, Ozikan, it's a financial for and a pencil, Yachia, Obibiara, Bibia, Wobia, and your host, Baka Brofo, na your resource person, so I can't tree another fancy. And see, we are going to give you a blend, and everybody will have a full portion. Nti update a ɔwɔ hɔ no nyinaa ne dɛ mmerɛ yɛnyim no autumn 2026 aban dze ɛyɛ indefinite leave to remain nsesan bebree na ɔdze ba na yɛnyim dɛ nkurɔfo hwɛ kwan bebree. Yɛnyim nso dɛ House of Lords dze hɔn ano tum dɛ dza aban pɛ dɛ ɔyɛ no nkyɛ ɔbɔboa dɛ wobetum asesam na hɔn a anka wɔwɔ ha dada wɔwɔ UK dadaw no wɔnhwɛ dɛ nka dɛm nkurɔfo no nsesan no a ɔreba no ɔnka hɔn na ɔyɛ advice sɛ wɔ aban bɛgye atum anada aban no ngye ntum no dze yɛnim ma obesi ba yɛbɔ mpae na yɛtwɛn ɛna ma ɔwɔ dɛ yɛhyɛ no nso nye dɛ Nyankopɔn yɛ adom a next year 2027 from the 26th of March 2027 so ɛkɛyɛ indefinite leave to remain a ɔwɔde kita B2 tisia no ɔyɛ B1 but ɔde kɔ B2 nti wɔma yɛnhyɛ dɛm ɛhɔ no nso sɛ ayɛ wo B1 anadɛ B2 especially B1 na sɛ ayɛ wo application for first 2.5 wetum ɛsan use ni biom because mmara no say use English language no na dza ayɛ application a botum use na dza ayɛ another application but sɛ atwerɛw ato hɔ na ɔyɛ B1 na use dza a sɛ bere no so a ɔwɔ dɛ ka kyerɛw B2 ɛna aba no so ayɛ bill foforɔ a waba a ɛyɛ nanse a na Ken ɔde ne nsa hyɛ ase na wɔhwɛ naturalization ho nsesan bebree na adze wɔn a wɔdze refugee status wɔde bɛkuru wɔn a wɔdze eduru wɔn a wɔdze visitors visa bɛɛ wɔn a wɔdze wɔkɔhyɛ car ase anada wɔkɔhyɛ ship mu wɔde bɛwura mu wɔn a kwan bebree a nkɔfo fa do wɔdze bɛɛ no aban ahu dɛm nneɛma no nyinaa even though mmara no sesa 2025 February no 10th of February 2025 and aban sesa dɛm illegal entry mmara no new bill na waba no so amen no mu ayɛ dzen paa dɛ sɛ yɛ obi a yɛ amfa kwan papa do na dze ba kurom ha ɔbɛyɛ dzen dɛ botum anya naturalization another citizenship na sɛ yɛ obi nso abɛ na ebedzi eduru a nso ɔbɛyɛ dzen dɛ botum anya naturalization another citizenship but yɛhwɛ ma obesi nti sɛ yɛnya nsɛm another information foforɔ a yɛdze bɛbrɛw dɛ mmerɛda bi a yɛyɛ no yɛbɛ make sure dɛ nso ate na etum de tu anammɔn a wɔbɛboa w'abusuafo na namfofo nyinaa. We are your community lawyers.
Thank you very much, Lawyer Charles. Thank you so much for the updates. Once again, we are live on BWTV. So welcome if you are now joining us. Welcome. Please do not forget to like the video and share, as you may never know who it will help. So yes, today our topic really is on, the do's and don'ts of switching from a 10-year route to a 5-year route visa. So there are lots of people who are currently in the UK, on the 10-year route, and they would like to switch, or they don't even know that they can switch to the 5-year route. So we've got Lawyer Charles here today to tell you how you can do it, if it's even possible, and what you can do to switch from your 10-year route visa to your 5-year route visa. You might never know, maybe you are doing something wrong and it could potentially lead you to a refusal. You don't even know that you can switch from your 10-year to a 5-year route visa. So our very good Lawyer Charles is about to explain what you can do and what you shouldn't do if you want to switch, and how you'll be able to get a successful application. Before we get to him, I would like to let you know that after this educational session, we will then open the telephone lines for you to call in and ask any questions you have, and all your questions will be answered. You can also put down your questions in the comment section. I would read it, and then Lawyer Charles would give you an answer to your question. So whatever you have on your mind, whatever questions you need answered, please don't and please don't be afraid to ask or call in when the telephone lines are open. So we are going to go back to Lawyer Charles for him to educate us on what to do and what not to do when we want to switch from a 10-year route visa to a 5-year route visa. Lawyer Charles.
Yo, medase, Pamela. Yo, etefo na ahwefo ende nso nkomo ne nyinaa yi de. Obi a owo 2.5. Na 2.5 no bi a ogina ne bado. Anada ogina ne kun anada ne yeredo a sebi obi bi nti wo hwe na wodze man no. Ba dodo na owo 2.5 no aya wogina wo bado. Nti ebegina hon a wogina hon ebado wodze gye no. Na obi kada so ogina wo no bado a ba asam na lawyer opa kire. Opa nye de ehuru ekegina wo bado. Na mmom mo yeka nyina yi de immigration mra na owo UK no ma kwan. De so obi inyi asetena na owo ba anodo owo abanuma otumi gina abofran no do na osre abande mebe nti woman bibi a motumi da atena na matumi ahwe abofrei ina emre no henedze na omakwan de dem abofrei obetum aboa na maame anada ne papa ma wenya asetena kakra ewo UK oman emu na emre no yehwe odika no wohwe abofra nankasa na otu ye do ebien wahwe dza papa no anada maame no eye dze boa abofraba no na otu ye do ba asan ya hwe de se aban amboa na wamfa nkrata ne bia ma maame na anada papa na obaha abofra no anada onha abofra no nti odika no ye behwe abofra no mrana front dam abofra qualifying child abofra mfaso wa no do de obotum aka de me maame anada me papa nti so metena krom ha one man bibi na dam emrano yefra no section 117D section 117D subsection 1 na dam emreno yehunu wo emre kasi bi a yefra no Nationality Immigration and Asylum Act of 2002 na dam section a yebodi mo aka nyina de so ye abofraba na indi 18 years na ewo British citizenship another ikita indefinite so ye EU indefinite another standard indefinite ikita indefinite another wow UK 87 years another wo abrochi na wadze ba UK na ebetena ha since abẹ ni nkọ ukru wọn fa nkọ baby atena ha 7 years another iye EU yin abofra ikita EU passport na eti UK yin ebusuafo te ha ikita either 5 years or EU indefinite them ma yɛabobɔ do nyinaa no sɛ abɔfra no wɔ bi a abɔfra no mmara no so ɔyɛ qualifying child na kyerɛ dɛ yɛ abɔfra ba a ɔdzi mu a obetum aka dɛ aban nhwɛ dɛm abɔfra no do na ɔma maame anada papa asetena nti na yɛka dɛ botum egyina dɛm abɔfra no do agye nkrataa na sɛ maame anada papa botum agyina abɔfra no do agye nkrataa ebrɛ kwan na papa yi botum afa anada maame yi botum afa anada baadze na papa yi anada maame a ɔdɔ ɔda n'edzi gye dɛ maame anada papa yi ɔyɛ obi a ne ho wɔ mfaso ma abɔfra no obi a ne ho wɔ mfaso ma abɔfra yi yɛ papa anada maame a Bronyi frɛ no a responsible parent na responsible parent no yɛ obi a ɔhwɛ ne ba ebi a abadae a ɔwɔ no ɔdze ma abɔfra no nti biribi ɔhaw bi na abɔfra no rekɔ mu a ɔhwɛ dɛ obeyi dɛm ɔhaw no efi hɔ nti Bronyi se dɛm papa yi anada maame provide psychological support, emotional support, financial support, physical support. Nti them support and care a maame another papa ɔdze ma n'abɔfra no nti. Maame another papa otumi gyina abɔfra do osan dɛ sɛ abɔfra pa me ni hɔ na papa ni hɔ a abɔfra no bibi bɔten because ogyina maame another papa do na otum ɔbɔ ne bra ɛwɔ UK. Nti imagine papa a ɔhwɛ ne ba another maame a ɔhwɛ ne ba na wɔsɛ maame nyi nkrataa nti wɔdze ne fi UK akɔ no kurom. Bronyi frɛ no removal. So wɔyi ne fi UK na wɔdze no akɔ no kurom dɛ onyi nkrataa nti wɔadi pɔt na kyerɛ dɛ abɔfra yi ba haahai. Abɔfra yi bɛyɛ bɛsaa. Bronyi se abɔfra no ne development ɛne ne well-being ɔbɛka ekyir. Dɛm nti ɔda yɛhwɛ na yɛma maame another papa nso 2.5 na ɔde tena UK na otum dze bɔ bra na ɔde boa abɔfra yi. Na mbra no ehende na ɔka dɛ ɔda papa another maame otum ɔkyerɛ dɛ ɔhwɛ ne bɛyi. Yɛhwɛ section 117B, section 117B, subsection 6 of Nationality, Immigration and Asylum Act of 2002. The amrani nyinara kan dɛ dɛm maame another papa ɔpɛ dɛ ogyina ne ba a ɔyɛ qualifying child do no ɔdɔ ɔkyerɛ dɛ ɔwɔ abɔfra no abrɛbɔ mu or play active role in the life of that child. Dɛm nti so nyi hɔ a abɔfra no n'abrɛbɔ bɛyɛ basaa. Nti na kyerɛ dɛ safeguarding. Nti sɛ maame ni hɔ another papa ni hɔ na abɔfra no bibi bɔtɔn another abrɛbɔ bɛyɛ basaa. Na da ɔwɔ ne nyin bɛyɛ basaa. Na kyerɛ dɛ ɔwɔ dɛ yɛdze bibi ɛma maame another papa no. Nti wɔn yɛnhyɛ dɛm mmara no nso. Na baadze mpo na ɔkyerɛ dɛ ɔwɔ dɛ yɛhwɛ na yɛ maame another papa no ɛboa ne bɛyɛ a ɔwɔ dɛ yɛma ne bibi. Mmara no bi a yɛfrɛ no section 55 of the Borders Act, Borders Citizenship and Asylum Act of 2009. Mɔkyerɛ nyinaa yi dɛ sɛ abɔfra yi a ɔyɛ UK ni ane dɛ ɔkuta indefinite and wait 7 years a ne maame ne papa na wɔhwɛ no anada ne maame nkoten anada ne papa nkoten na ɔhwɛ ni sɛ oyi papa no firi n'abrɛbɔ mu a abɔfra ne nyin anada ne kankɔ ɔbɔtɔ sim. Dɛm nti it will not be in the best interest of the child for the parent to be absent in the life of the child. That is the law. The same thing na ɛkɔ court nso a court nso esi do dua dɛ sɛ dɛm na ɔte dza a mbra ɛmma kwan a ɔbɛboa abɔfra yi dɛ maame another papa a ɔboa ne ba no wɔnyi ne fi UK another wo man nkrata obetumi za aboa na oda hwe ne bei nti dodoɔ na wɔwɔ ba dodoɔ na wɔwɔ manoma no wotum wogyina dam mredo ɔde application na sɛ yɛhwɛ paragraph EX1A of appendix FM na ɔbɛka kyerɛ dɛ sɛ maame another papa a unqualify na ɔbɛnya indefinite ɔbɛnya 2.5 no sɛ otum kyerɛ dɛ abofra no ohia no wɔ n'abrɛbom na otum kyerɛ dɛ ɔboa abofra no ɛwɔ ninyin na ne kankɔ ho a ɔwɔ dɛ wotum wɔdze nkrataa no ma maame no osan dem even though maame no qualify no sɛ wɔamfa nkrataa no amma no a ɔbɛhaw abofra no nti na kyerɛ dɛ maame no qualify another papa no qualify nso paragraph EX1A of the immigration rules ɔwɔ appendix FM hɔ no ɔkyerɛ dɛ case worker sɛ maame no another papa no qualify a ɔwɔ dɛ ihwɛ bibi foforo ansa na refuse application no nti bebre na dam kwan na yɛafa do a yɛnyɛ 2.5 but obi o ma dem ra yɛka no ɔyɛ application ɔnangasa onyi nkrataa osan dɛ sɛ yɛ nkrataa ɛda da bɛyɛ application as parent another bɛyɛ application as partner either parent or partner no yɛhwɛ appendix FM of the immigration rules yɛwɔ nkyekyɛm bebree yɛwɔ validity of the application yɛwɔ relationship requirement yɛwɔ financial requirement yɛwɔ immigration status requirement ɛna yɛwɔ eligibility requirement suitability na ade nyinaa wɔ hɔ but suitability in deɛ wɔma yɛnta ase dɛ obi a odi ne ho yi ɛwɔ UK no ɛkyɛ dɛ obummra dɛm nti dɛm nyimpa na odi mmara no do no bibi a yi hɔ a ɔbɛkyerɛ dɛ ne suba ne nyɛ nti suitability de yɛdze ato nkyɛn yɛtaking dɛ obiara qualify under suitability na eligibility no ne fa no bi no ɔse sɛ botum ayɛ application as a parent a wɔ application no case worker no bɔhwɛ no mmara ne fa bi a yɛfa no paragraph ELTRPT 1.1 PT means parent nti E ne eligibility L limited and T 2 and R limited leave to remain. Nti eligibility requirement and the limited leave to remain for parents. Nti na ya twa senior friend no ELTRPT 1.1. Ɛhɔ no yɛ mmara case worker no bɔhwɛ na ɔdze ayɛ assessment there application a parent no dza aba no won refuse no another one farmer. Na parent yi sare yɛ dam application a ɔwɔ dɛ ikyerɛ dɛ odikan ɛwɔ immigration status a yɛfrɛ no immigration status requirement otuado ɔwɔ dɛ ikyerɛ dɛ abofra no ɔyɛ wo ba another ɔyɛ wo abanoma another wɔ aban tum dɛ ihwɛ abofra no nti wɔ parental responsibility under relationship requirement ɛna ɔwɔ dɛ ikyerɛ dɛ iwɔ sika botumi da ahwɛ wo ho da ahwɛ abofra yi sɛ yɛ adwuma 29,000 a year sɛ nyɛ adwuma nso na dɛ adwuma yɛ no ɔnkɔ ahen bia nso a ɔda kyerɛ dɛ sɛ yɛdze wo toto obi a ɔgye benefit ho a you meet maintenance requirement a benefit equivalent no sɛ tua wo rent na sɛ itua wo council tax a ma ɔka no botum da ahwɛ wo ho every month sɛ dɛ obi a ɔda benefit do nti obi a ɔnyi 29,000 no ɔda ɔkyerɛ maintenance adequate maintenance requirement under appendix FMSE a yɛfrɛ no specified evidence ɛhɔ no. The mara nso ɛna dɛm nyimpa yi ɔwɔ dɛ ɔkyerɛ dɛ ɔwɔ English language under English language requirement. English language no ɔwɔ dɛ ɔkyerɛ dɛ ɔwɔ mo odo ohia dodo na no and the basic level no A2 which means so I throw B1 but so kwa akoye them application na nyama for amabobodi inya na chere dem qualify. One, immigration status. Say in criteria and qualify the buyer application for 2.5 as a parent. Two, say new relationship with abufrana and qualify. Three, English language in Inya and qualify. And 4, maintenance, another financial requirement in Inya and qualify. Into be unqualified no, obey them. A one in a paragraph EX1A of Appendix FM to the immigration rules or there. Some qualifier another say requirement no another qualification nyini nyina na ɛwɔ a na ɛwɔ ekurumpo a botumi gyina do na dza ayɛ application as a parent. Nti 4 year ya bobodi ehinze na hwa obi botumi wenya. Ne ntumi yɛ application abra in your parent. That means say enya English, inyi immigration status, another you overstayer. Na say inyi maintenance at least about relationship evidence no because you can prove with your birth certificate another DNA say pa which means they prove there abofra no oyawoba and now put there which mean ya birth certificate in a marriage certificate you that dance that abofra no your step child and now put there which mean ya court order actually there it was parental responsibility e wa abofra the life do a all na ebo them brano another issue abofra as a parent. Nti ni nyinaa no akwanya ɛwɔ hɔ. Mpo sɛ nware maame no another papa no na sɛ yin papa yi another maame etu kwan ka de etu kwan a relationship akwantu nyina etu kwan na nyina wɔ relationship mu for 2 years a mmara ne se ɛwɔ default relationship and as a partner ɛwɔ dem nyimpa no do dem nti dem abofra no a aware no maame another aware no papa yi no ɔbɛyɛ wo step child by default. Nti nye obiara na ɔwɔ dɛ ɔware ansa na abofra no abayɛ ne step child. Say it was guardianship order another it was court order as a step parent another nye maame na another papa no I wɔ hɔ for 2 years papa no ma ne ba no another maame ne ba no abayɛ o step child. Nti abobɔ do na kyerɛ dɛ dodoɔ na no so wɔkɛyɛ application na wɔ meet requirement na so otumi wonya ekor a ɔyɛ relationship a otumi gyina do under paragraph EX1A of Appendix FM to the immigration rules no otumi gyina hɔ na wɔde yɛ application na otumi wɔhwɛ dɛ abofra no na abrɛbɔ na adze nti so wɔfa ama hɔ na abofra no nyama bi ni nkɔ yie man. Nti ɛmfa dɛ obi wenya wagina dam kwan no do why application wa man 2.5 because the nipa no qualify nti was no about 10-year route no do 10-year route no you find your bus into your slow it will take you 10 years to get to the destination or your 10 stops no until every 2.5 or there you renew 4 times. That is the rule. Now, so be our qualifying a day, obey no under 5-year route. Into no be take 2 stops in the way to destination, final stop. Inti same qualifier was obodo say new requirement ni nyina was obodo 10-year route no do. Na say requirement ni nyina was obodo 5-year no do. In the nkomo aye din there say ishas no in qualify in the was to 10-year route no do. Na epede switch ko 5-year route no da e baadze na owo da ye na baadze na onyi da ye do's and don'ts when switching from 10-year route visa to 5-year route visa. Do's: do make sure that you meet all the requirements for 5-year route. That is number 1. Do make sure that you meet the requirement for 5-year route. Me picture in there. Over there, share there. It was 5-year route. No requirement ni na. Odikan. It was visa. Nimpa was 1 month 2.5 and the 10-year route. No, that share there over visa until 2.5. That will take immigration status requirement. So make sure that we visa are valid. Number 2, do make sure that the relationship is still intact. There's no issue with court order, no. Another, there's no issue with stepchild, no. And then there's no issue with your own child. So the relationship is still intact. Obi said that, there's someone who there's no way of us. Yes. Obi ma neba no, oye ne badze, ne mbom, onhwe ne biem. Another oye na abanoma, but maame na onye no ho no, onyi ne ho biem. Another papa na onye no ho no, onyi ne ho biem. Nti papa na anam no do mabaya abofra na abanoma no, another ne step parent, another father or mother no. So papa na another maame ne onyi ne ho biem za, na chere them step parental relationship no so onyi ho biem. Another woba no kra mpo no abana agye na afi wo nsam ama maame no because abana hu there he useless. Azo it's not that would there ya papa another ye ja but mfaso bi anyi ho emma moframba na che there mfaso yi ho. You don't meet section 117B subsection 6 of Nationality, Immigration and Asylum Act 2002 now. Ya board no. We send there. You don't do anything for the child. So what is your use in the life of that child? Nti se bibi aka sesanda medza obayedzin they both may prove there your relationship and you play active role in the life of the child. Nti amfan there one more first 2.5 no everything na one is still intact. Man na nyipe English, finance, in immigration status. Since 1 or 2.5 until now you have immigration status. Aye juma 6 months. Now you have financial requirement of at least 29,000 because iye juma woche account 30,000. Aye juma now for 6 months, another 7 months. Now you meet the financial requirement. Then the next stage in there, abo madina actual English in your A2. Ompo abo ho madina pa in your B1. They meet English language requirements. Nti yɛhwɛ all the 4 requirements as is ɛwɔ ne nyinaa. Ɛwɔ relationship requirement with the child. Ɛwɔ English language requirement. It meet financial requirement. And that it meet immigration status requirement because it's ɛwɔ 2.5 and a 10-year route. Na kyerɛ dɛ ɛkwan wɔ hɔ dɛ botuma yɛ application under 5-year route. The salary application under 5-year route now, you cannot rely on paragraph EX1A because them EX1A no, for one won't meet some of the requirements. In the sense, it meet requirements in it that your application no, them obia or qualify or by in the pay what second do in there or make sure that all the requirements are met. Another one, or make sure that the relationship is intact. And now, our applications are one of the do's in there. Should there switch about 10-year route in that about from 10 to 5-year route now. Timing are important. Timing. As you know, what's the room 2.5 for not in your 5 years, not a year application for indefinite. 2.5 no. Imagine there, Tama a switch about 5-year route no from 10-year route no already no a year applications 2 under 10-year route. In 5 years that now. About the 5 years no so da manoroba shase na etra another 5 years. What's the point? Waste of time. Waste of your brain power to do the exams. Waste of all the things I have about no. Into the moment would there at 10-year route no do that would at 10-year route no 5 years no. If you do there switch about 5-year route no. Into moment share a no and so. So do make sure that as soon as you are given a 2.5 years leave to remain visa under 10-year route and you have worked for 6 months, you switch to the 5-year route. And the man may lose about 7-8 months. Then you can save a lot because you were 2.5. Now, you 1 year cry, you still save 1.5 years. Then your journey to indefinite, obey in term to my share a so and so. So the do's, do make sure that you meet the requirement. Although with the requirement in no, so switch from 10-year route to 5-year route. Odi kan so otuado, do make sure the relationship no on sign. Otuadi do make sure the actual English enya A1, sorry, A2. Do make sure that iye adwuma a wotua oka 29,000. Na sɛ nyɛ adwuma koraa sika ɔba wo ntɛm a idididi no ɔyɛ enough a botum de ahwɛ wo ho a ɔnhia dɛ bɛkɔ akagye aban benefit another aban nsɛm sika. Nti dues no na yɛabobɔ do no. What are the don'ts? Don't ni nyinaa nye dɛ sɛ tumi inya dues ni dza a anasɛ ntumi anyɛ dues no a anasɛ tumi yɛ a then ma ɔnhia dɛ bɛyɛ no already no na kyerɛ dɛ ɛdze ato nkyɛn. Nti sɛ pɛ dɛ switch from 10-year route ɛde kɔ 5-year route na yɛsrɛ bebree mantena hɔ a na nka dɛ menya meka yɛ me third renewal na third renewal na meka yɛ no pɛ dɛ meyɛ no under 5-year route mfaso ni do asɛ ne dadaw. Don't waste time. Nti don't wait till it is too late. Don't wait till the ɛka third renewal ansana mpo second renewal ansana ɛbɛyɛ switch no. Now the next one there, another don't no so in there. So yeah, application a hwɛ dɛ sɛ ɔwɔ dɛ ɛkyerɛw English a ɛtum atwerɛ apass ɛwɔ certificate no. Ɛwɔ certificate no. And now don't also just submit foreign certificate, another foreign English language proficiency letter without actors. In the Sabia school, it a foreign degree. Now, so make your application, may switch. Don't just submit that English language proficiency letter or that certificate. Or there should there, it's a come actors for formerly no from a NARIC. It's a come one, why assessment, why to me there. Who degree now I want because the watcher has do English in it or equivalent to safer C1 level. Nti mayabu no do's and don'ts from 10-year route visa to 5-year route visa as a parent of a child who is a qualifying child. Nti yɛdze besi ha na sɛ nsɛm bi wɔ hɔ a ohia dɛ yɛbɛyi ano a yɛyi ano na yɛdze foforo aka ho.
Thank you very much, Lawyer Charles, for this educational topic. So I hope you've all learned something today. If you are a parent of a qualifying child, you can switch from your 10-year visa to a 5-year visa. As Lawyer Charles has explained, if you want to switch, you need to make sure that you meet all the requirements under the 5-year route. That is, you should make sure that you have your immigration status. So if you are on the 10-year route, means you have finally gotten your first 2.5. So you do have a valid visa, and which means you have an immigration status in the UK. So it will be possible from that point on to switch to the 5-year route. You also need to make sure that you meet the financial requirements, which is for maintenance. You need to make sure that you've also met the English, which is go and take your English test. You can take the A1, A2, but you can also take the B1 test. Make sure you pass it. You don't just take it, but take it and pass it. And then once you meet all these requirements, you can then apply to switch your visa from the 10-year route to the 5-year route. And please, just as he said, timing is important. So if you are already on the 10-year route and you get your first 2.5 and you get the next one, which means you have already done 5 years, before you are now thinking to switch to the 5-year route, you are going to start again and be on the 5-year route, which is still 10 years. So then there is no point. So after you've gotten your first 2.5 year, you can then switch on your next extension to the 5-year route. That would help you not stay for the whole 10 years. So please don't forget that timing is important if you want to eventually switch. And he said for the don'ts, if you have a certificate from a foreign institution, don't just submit that certificate as part of your application. Make sure you take it to ECTIS, which used to be UK NARIC. Take it to them for them to verify that it meets the standards of the UK, and then you can send that certificate with the one from ECTIS with your application. So thank you once again, Lawyer Charles, for this very educational topic. We are now going to open the phone lines for you to be able to call and ask any questions you have. So our phone number is 073-9920-8468. I'll repeat it. It is 073-9920-8468. You can give us a call and we will answer any question you have. Please also don't forget to share the video. Don't forget to like it and comment. So if there are any questions, we would take them and we would answer them for you.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to Legal Hour. So before we get to the questions, Lawyer Charles, we have a quick question for you regarding today's topic. We would like to know, does the switch is it available to anybody who was given their first 2.5 when they were overstayers?
Yo, me that's bebre, Pamela. Na za owoda yeshen so in there. Say one first 1.5 a kwana inyan no efedu nyan so ohia pa. Obi mu a owoba. Maame no na onya abofra no te, na ono so te baby. another papa no ya abofra no te na ɔno so te baby. Obi said that is it possible them abofra no papa no te na maame no te baby? Yes. There were about 2 applications me yeah maame no na ogina abofra no do na ɔde yɛ instead of that papa no be gina abofra no do no because abofra no papa no te na maame no ɔkɔ kasra abofra no ba maame no hɔ na we share on McDonald's for child arrangement purposes. Nti maame no gina abofra no do na ɔgye. Now, say maame no te baby na abofra no iti baby with the other parent wɔfrɛ direct access. Direct access. Now, my parent or what direct access no. So when the first 2.5 and the 10-year route now, or qualify there, or switch up 5-year route no do. Direct access. Let's say inye maame no another papa no na abofra no nyinti mbom as a family it will easy access to switch from 10 to 5. What about the Watibum as a family? Watibum as a family in addition to EX1 na nyimpa no gyina do ɔdze nya no first 2.5 no. Nyimpa nso gyina Gen 3.1 3.2 of that's paragraph GEN 3.1 3.2 of Appendix FM to the immigration rules. Hɔ no ma ɔkyerɛ nyinaa dɛ ebusua no nyinaa wɔte bom. The mother, the father, and the child live together. And because of that, say application na nyimpa no yɛ no, wɔdze bama ɔma no first 2.5, but wɔdze bama as partner, even though ogyina abofra no do, wɔdze bama as partner. Nti sɛ woman first 2.5 na ɔkɔ switch akɔ 5-year route no da. One man 2 years under 5-year route, Obama still 2 years under 10-year route because they are still looking at the partner. We look at the about why. That is the law. That is the rule. At the Embrano a reward nkrofo ebusua no ebi ti baby na ebi so ti baby na o punish ebusua ho nyina woti bom. Whatever it is it is what it is. But for us we are supposed to tell you the difference. So if you're on a 10-year route na enye abofra no na na maame another abofra no na na papa nyina na what's ntumi switch nkɔ 5-year route because mmara no ɔma kwan dɛ botum egyina abofra no do na a switch ma wayɛ yie nti wɔma yɛnhyɛ ɛhɔ no nso. Pamela, that's the response.
Okay, so if we understand clearly, you are trying to say if you are living with your partner and your stepchild, and you even apply under paragraph EX1, which is as a step parent, you will still be given your leave as a partner, not a parent. And so you will not be able to switch to, 5-year route if you apply again. That's if we're understanding you clearly. That's what you're trying to tell the people today.
Nokwar dam na yɛpɛ akyerɛ. Na yɛpɛ akyerɛ nyinaa dɛ sɛ abofra no ɔnte baby na also it's baby dza. It doesn't really matter whether you switch or you cut or you paste. Obama the same 10-year route visa no. Nti viewers and listeners, Oma yɛnhyɛ ɛhɔ no nso. Yes, you are right. Pamela.
This is a very important point. So I'm hoping that everybody listening has learned something as well from this. That if you don't have direct access to the child, that is because you are living with the child's other parent as well as your child or your stepchild. You will be given your leave as a partner under the 10 years route. So even if you apply to switch to the 5-year route, you would still be given your next 2.5 as a partner under the 10 years route. So you would continue under the 10 years route. This is a very important point. So now we are going to start taking our questions for Lawyer Charles to answer them. So please don't forget, if you have any questions, you can put them in the comment section or you can call our studio line. Our studio number is now open. It is 073 99208468. You can call in and ask your questions. Thank you.
Okay.
So we've got a question from Edubuahen. He's asking, if you have a pending application that's 2.5, can you write the English test before the decision comes out successfully?
Yo, Edibo Ahen, question Adabe, Yantase. Do you need the English language for that 2.5 application at that to that down? Or you need the English language for your future application? Or you need the English language to keep for whatever reason? I will answer in all 3 points I may raise. Point number 1, say a cultural English language to support application I submit that out there. The moment you go for your fingerprint, there's no opportunity to submit evidence. In the cultural English language, while the visa application is pending and you have already know in fact you would have cultural English for that application. But cultural English is a to for application but another time it's a yes but to my here because there's no bearing of that English language in a pedetron on them pending application no.
Okay, thank you. We've got a question on our comment section from John Joe. He says, good morning, lawyer. Good morning to you. If I started on 5-year route as a spouse and 4 years later switched to 10-year parent route due to a relationship breakdown, will time spent on the 5-year count on the 10-year route to indefinite leave to remain?
Yes.
This answers you. So yes. Our next question is from Citizen Kojo. He says Kofi has already passed both the B2 English test and the Life in the UK test. If the new threshold rules come into effect for indefinite leave to remain and British naturalization respectively, would Kofi need to retake either of those exams, or will the certificates he has already obtained still be accepted?
Yo, Sir Kofi use them English language in it now or application. Now application why a year that it will be a case worker is a valid application. Valid application application akobo san one reject. And just the way use B2 that application. Now application one reject and then go through there. Or what you may use B2 another time. But so throw B2 to her. And when you saw my B2 newu after 2 years there, or does throw another B2.
Okay, thank you. Thank you very much. We've also got a caller on the line. Good morning.
Good morning, Pamela.
Good morning. How may we help you?
Yeah. Acho, Salem, I'm saying. Me wa mami no. Omo Ghana. Omo ya British. Ba me anso mo kronga me wo yere. Na me pese nkankura no omo do omo school press. Omo ba kronga ba ko school. Nti campaign na metumi ama maame no ne nkura no aba school.
Okay.
Akonya kura be transfer so ne maame na bank o mama mo made na how had the onion made.
Okay, Laura Charles, please, did you hear the question?
Yes, I did. Director, let us say. Director. Director, let us say.
Nyamiadum, na wonso.
Nyamiadum, me hoye. What's it? What's it when you're in the UK?
Mpacho, many UK ha. Na menu bi so awo Ghana.
Don't worry about the rest. Don't worry, just follow me. Just follow me, Pacho. Etima, follow me. Listen, you're here in the UK, me boy.
Ne mpacho.
Yes. Okay. And now it was emba too. It was Ghana. We are British.
Yes,
From
Macho.
but in Kolano, omo maame de we Ghana ni.
Ghana is up.
Nti nkwalaa no na wopɛ sɛ ɔmo ba anaasɛ nkwalaa no maame na wopɛ sɛ nka ɔba na ɔbɛhwɛ saa nkwalaa no.
Nkwalaa no na nka bɛ sɛ ɔmo ba na maame no bɛhwɛ ɔmo. Sɛ ɔmo ba ha me nya brɛ ma ɔmo na me no so ntimi nhwɛ ɔmo.
Okay. Matias. Yo, nea wobɛtumi ayɛ ne sɛ maame no tumi ba mu because maame no ntumi mba sɛ ɔba wo nkyɛn because wonyɛ maame no akunu. Nti maame no ntumi mba sɛ ɔba wɔ hɔ. Ɛna maame no nso ntumi mba sɛ nkwalaa no nti ɔbɛtena ha because nkwalaa no ɔmo papa wɔ ha. Ɔmo stepmother nso wɔ ha. So there are parents to look after them. Nti nea maame no a ɔwɔ Ghana no bɛtumi ayɛ ne sɛ ɔbɛhwɛ sɛ ɔbɛnya visitors visa afa kwan bi a ne sɛ ɔbɛpa kwan foforɔ so. So ɔbɛwura mu a.
Sorry, can you repeat what you were saying, Laura Charles? He did not hear you clearly.
Mese maame no ontumi mba sɛ ɔba wo nkyɛn na ontumi mba sɛ ɔne nkwalaa no eba because ɔbɛhwɛ nkwalaa no because wɔ hɔ. Nea maame no bɛtumi ayɛ ne sɛ ɔbɛpɛ kwan foforɔ so ɛbɛwura mu. So bɛwura mu wie a na waswitchi akɔda ne mma no so because that time no wɔ kurom ha sei. Nti obɛtumi aswitchi akɔda mpo so ɔde visitors visa na ɔde baeɛ na visitors visa no ewu a sɛ nkwalaa no wɔ ha nko ade a obɛtumi aswitchi akɔda nkwalaa no so because ɔno nso yɛ parent.
Okay. I see. Your next invitation and visit and I say.
Well, I don't know. Me say so they do UK. Kwan obafa so they do have there. I don't know about Nasi. Or the visitors visa na oba kwan ben so na oba as a visitor. Obesra wan. Ana oba or you be obetumi aba school.
What you say?
Or you be obetumi akasa oba school ana. When you be obetumi aba school. And you know say out, school you out. And obviously so akasa nuku aware na nukunu edne badia and the ohia nkwala no to give her this salary. And the only options are kwan obafa so obenya visitors visa or the baby remu no. Otumi be remu nko ade a ekwan ne bebie ama no because obe remu a na nkwala no so ayeden aba. Nkwala no ba nkwala no omu hia visa, omu ye British citizens. To omu ba ho. Nti sɛ nkwala no wɔ inside na ɔno so wɔ inside there a obetumi ayɛ application so ɔkɔda nkwala no so.
Okay, man. That's it. Lawyer.
Thank you.
Actually, my friend. Na okay.
Thank you.
Yeah, that's the camera. Bye.
Bye. Thank you. Okay, so you can call our studio number on 073-9920-8468. Our telephone lines are open. So our next question is from citizen Kojo. Kofi previously had an IVA and a driving offense, both of which have now been completed or have expired. Given that these are part of his past record, will they affect the Home Office's assessment of his good character when he applies for either indefinite leave to remain or British naturalization?
Yo. Zayabaka kyerɛ Kofi dɛ ordinarily, it's a big word, ordinarily, under normal circumstance, sɛ yɛhwɛ ne saa nko ade a ka yɛbɛka sɛ Kofi suban no na ɛnyɛ. Nti na ne suban no nyɛ deɛ a ɛsɛ sɛ ɛtumi affect ne character. However, there's biribi a yɛfrɛ no mitigation ɛwɔ suitability requirement no mu. Mitigation sɛ ɛdi kan how long nti sɛ bi a Kofi IVA anaasɛ driving offense no a or committee ye punishing ye and say we film. Sisi ano why reformed or good character bibia di adanse here. Kofi betumi plead say yes, I offended on this count some time ago, about 5 years ago, 3 years ago. I was given driving offense. I've gone through that. I'm now driving. I've been a good person. IVA was because I couldn't pay my bills and things were so bad, family issues, and I had to voluntarily ask for that. And so it affected my credit and my ability to access finance. But then I've gone through that stage, and now even my credit score is excellent or good. And all that is my past. And so, considering the fact that I have been a responsible member of the community, they have to consider that. Then you write nice mitigation, supporting it with evidence. Then you add it to your application for indefinite or naturalization.
Okay, okay, thank you. Our next question is from Lydia Opoku, sorry. She's asking, please, my brother has had his ILR in June 1st, 2025. Can he apply for citizenship now? Thank you.
Lydia, I would there you kwana wo brother offer do indefinite leave to remain. Inti misrawa whatever ever back. Because our brother no onya indefinite leave to remain as a spouse of a British citizen, spouse of a British citizen. Them za obutu aye naturalization the next day. But so when you know as a spouse, dear, it will be difficult to do. That one will come under section 6, schedule 1 of the Nationality Immigration Asylum Act. Sorry, of the British Nationality Act 1981. British Nationality Act 1981, section 6, schedule 1. I have from conform naturalization application. One of the requirements, 1 year indefinite. Na exception no nkrofo a omunya indefinite no as spouses of British partner or British citizens. In that case, right away they can apply. Into Lydia, ask your brother how he got indefinite leave to remain.
We've got our last question for today from Evans Rockshell Sikanate. He says, my mom came as a visitor to the UK in 2013 and she has overstayed. Is there any chance of her getting a visa and what can we do?
Yo, Evans, 2013 to 2016. That's sorry, 2013 to 2026. That's about what 19, right? No, how many years is that? So 2020 is 7 plus 6, making 13. So that's about 13 years. Until Oma maybe train for 7 years more. Now I hear application under private life under paragraph PL 5.1A of Appendix Private Life to the immigration rules. Because or you overstay and we check 20 years by that time. See, I need 20 years. And don't mean yes, our application. Unless I want worry, na nukunu disabled. Nukunu hiano. Na or argue say oja nukunu wɔ hɔ a nukunu bewu ato no so. And I say ade asama ba nti omo consider no. Now in that case no maame no buy application under appendix FM paragraph EX1B for partners with exceptional circumstances or insurmountable obstacles. Other than that, the answer is no.
Okay, thank you very much, Lawyer Charles. The producer has told me that we've got one last question from Kofi Nat. He says, Lawyer, I have applied for indefinite leave for 5 months now and I've not gotten any response. Please, what should I do?
Yo, Kofi Nat, Keep waiting. Keep waiting. Keep waiting. It will come. 5 months is not a big deal. Enche, ebeba. Ebet may take you 1 year. And say, if you say, oh, too quiet, and I say, be been to me in China, just write to them. But even that, they will write back to say, train, a year radio, Usa Ebeka, and that's our Yanka. So just wait, pray, and live your life.
Okay, thank you very much, Lawyer Charles. Thank you to everybody who has joined. You can locate BWF Solicitors on the fourth floor of Anna House, 218 Tottenham High Road in London. The postcode is N154NP. They are very good when it comes to immigration law, family law, civil litigation. So if you have any legal matters, please come visit us. BWF Solicitors, located on the fourth floor of Anna House, 214-218 Tottenham High Road, London, N154NP. The closest train station is Seven Sisters using the Victoria line. You can also call the office number to book your consultation on 020-8493-7340. I'll take that again. The office number is 020-8493-7340. So you could call them to book a consultation for any of your legal matters. The emergency number is also 077-1276-1884. I repeat, the emergency number is 077-1276-1884. Please do not call if it's not an emergency. Call the office number, because the emergency number is strictly for emergency. So if you want to book a consultation, call the office number. Only call the emergency line if it's an emergency. We've got a lot of people calling emergency number when they don't have an emergency and they want to book a consultation. So please don't forget to call the office number for your consultation bookings. They are once again located at Seven Sisters. So you come with the Victoria line, exit 4 is your best exit, and you come and then get your legal matters sorted. So thank you for calling. We'll go back to Lawyer Charles to see if he has any last words for us before we end today's program.
Thank you very much, viewers and listeners. We usually wrap up in English. Today, we were privileged to have our host helping us with English right from start. So at least those people who would usually say that I didn't understand, I was disadvantaged, you didn't consider me, have all been considered. So we ensured that there had been full differentiation covered, and we have met the Ofsted test if it were to be classroom. So I'm going to wrap up in English. Today we looked at do's and don'ts of switching from a 10-year route visa to a 5-year route visa, especially for parents who applied on the basis of their relationship and parental responsibility for their children and stepchildren. We understood that in terms of do's, you have to make sure that you do meet all the requirements for 5-year route visa. The requirement for 5-year route visa are immigration status requirement. So if you want to switch, make sure that you do check that your visa is still valid. Also, we said that you do check that the relationship with the child is still intact and nothing has changed. You do check that you have now met the financial requirement or the maintenance requirement, i.e. 29,000 before tax for a year if you are working, or 29,000 before, 29,000 after 29,000. So we have 29,000 before tax if you are working, and 29,000 profit before tax if you are self-employed. So that is one thing that we can consider for those who are self-employed. Some people would have gotten 2.5, started their own business. They are making so much in terms of profit, and they want to switch to 5-year route. They can rely or use the profit that is reported In this case, you have to show that you have submitted your self-assessment tax returns to HMRC, you have UTR, you have 12 months evidence of the income, and you have your accountant's report confirming that the accounts were prepared and the monies were verified and the tax is as filed. Then you can rely on that. Otherwise, you can also rely on the maintenance threshold for adequate maintenance, where you can compare yourself to somebody on benefit. If the person on benefit is able to survive on X amount, and you are not on benefit, but you also have X amount before X amount after your national insurance, after your council tax and your rent is paid, then you can use that to evidence the finance to make an application. And the final bit for applying to switch from 10-year route to 5-year route is the English language A2, or ECTIS comparability letter if you have a foreign qualification. We also said that do check whether you are still living with the family or you have access to the child and you live elsewhere. If you live elsewhere and you have access to the child, we say you have direct access. You can apply to switch to the 5-year route. If you are living together with the child and the mother or father, then it's a family unit. You cannot switch from 10-year route to 5-year route. In terms of don'ts, we said that if you're able to tick the boxes for do's and you are clear in your mind that these are the things you have to do, then make sure you don't do otherwise. Otherwise, you will not be able to switch. These are the points we raised from these conversations and the information we shared. We believe that it's clear to you that if you want to switch 10 to 5-year route, you are able to assess yourself to know when and how to go about making such application. Thank you.
Much, Lawyer Charles, for this educational topic today. Thank you to all our lovely viewers for tuning in today and staying with us to the very end. Once again, please do not forget you can always come to BWF for your legal matters, whether it's immigration, family, civil. You can come for your legal matters to be resolved, and you can call the office number to book for your consultation. They've got lots of solicitors who are ever ready and willing to help you with your legal problems. Thank you. I have been your host, Pamela Oakley, and our resource person has been none other than Lawyer Charles Asma. So thank you all once again for joining us today, and we hope we'll see you again next week, and hopefully we will have Maniati back on Legal Hour to join you next week. Thank you very much. Have a blessed day.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.